Please be seated. The court is now back in session. And once again, the floor is given to Nunji's defense to continue putting questions to the witness. You may proceed.
Thank you, Mr. President. Good morning again, Mr. Header. Right now, I would like to turn to the topic of the methodology of your writings and your academic publications. Before I come to that specific topic, I would like to ask you a question in respect to the answers that you have been giving today and the previous days. From your testimony, it is clear that you did extensive academic scholarly research in the 80s and the 90s. In 2006, you started working for the Office of the Investigating Judges and were detached for a while with the prosecution. Afterwards, when you left, you continued writing at least some publications in respect of politics in Cambodia, sometimes making references to the DK period. My question to you is, when you were giving the answers to the questions of the prosecution, and when you were asked to give evidence as to whether sources were confirmed by other sources, etc., were you able to distinguish between the knowledge that you have gathered in your scholarly period, so to speak, and when you were working as an investigator?
Generally speaking, I think, yes, I certainly tried to do so. Of course, realistically speaking, I don't have even the beginnings of a case map, much less a Xylab, in my head. So it's not always possible for me to be absolutely certain that I can segregate in my own mind what knowledge came to me when, via what channel, as the result of what work. But I've tried to, I'm aware of this distinction, and I've tried to segregate to the best of my memory and the best of my mental capacities out the various parts of the knowledge and the provenance thereof.
Then are you saying that the answers that you have been giving in the past days are based on your knowledge gathered in respect of your academic publications and not so much as to what you have learned through the investigations?
Yes, that's what I've attempted to do. And with regard to the period that the Khmer Rouge were in power, I think it might be useful to go through that. I did some work on the Khmer Rouge before they were in power when I was in Cambodia 73, 75. And I've indicated that I attempted to look at policy structure and organization, both as it related to the situation between 73 and 75 and as it related to the origins of the movement. That was the archive RAT in the National Library in Cambodia, and also some field interviews. I followed the Khmer Rouge in power to the extent that I could, the limited extent that I could while I was at Cornell. And then after that, in a series of capacities, I looked both at the post-Khmer Rouge period and the Khmer Rouge period itself. And I've tried to, focus on the parts of my work that relate specifically to the Khmer Rouge in power, so delimited by what I understand to be the temporal jurisdiction of the court. And have kind of a reversal of the situation I face now. There was a time after January of 79 where everybody was interested in what was happening after January 79, and I had to kind of make time to look at the Khmer Rouge. Now I've reached a situation where I've tried to reverse that polarity.
One last question on this particular topic. I know it's a difficult question, but are you able to make a distinction in the sense of your post-investigation academic articles and your pre-investigation academic articles, in the sense that you maybe not have changed your mind academically in respect of the decay period 75-79?
If memory serves, there's only one piece of writing that's come out about Khmer Rouge policy since I left the employ of UNAKRT, to be precise, which was in May 2011 that I left, I think. And there's one piece of work that relates to Khmer Rouge policy, not practice so much, but policy, that came out later, based primarily on revolutionary flag stroke based on the ones that were already in my possession, either in original form or in photocopy form before the tribunal started, plus some in-court, open-court testimony. And in that I tried to elaborate on some of the themes that I put forward in the paper before the German Historical Society, which later led to the summarized, shortened version that was an academic publication under the general rubric Senior Leaders and Local Authorities. And in that regard, if you're talking about my thinking, I think the crucial turning point is my stint as a fellow, research fellow, at the Center for Advanced Holocaust Studies in Washington, which is a part of the U.S. Holocaust Memorial Museum. And I sort of went there. That's late 2001 to early 2002, if I recall correctly, after 9/11, whenever that was. And I went there with this notion in my head based on my previous interviews, including the ones I did in the 80s, of there being a significant amount of local initiative, local deviation, local power in the overall picture. And I sort of went there with some to the Center for Advanced Holocaust Studies, which is sort of one of maybe the highest level place for studying the Holocaust, with some trepidation, fearing that I would go there and see myself seen, as I put it in my worried head, as the David Irving of Khmer Rougeology. That is to say, someone who was putting themselves effectively in the position of what some would say is Holocaust denial of a sort, only to discover that the way in which I had come to understand the Khmer Rouge regime based on my previous work was pretty much in line with at least one major part of Holocaust studies, which precisely puts an emphasis on local initiative, local deviation, local power, as opposed to the old model of totalitarian control, a model which in academic circles has pretty much long since been seen as discredited and discarded as a way of looking at how these kinds of regimes operate.
Now, I take it from your answer that that particular academic stance has maybe also led to the article reassessing the role. But if I make it more general, more broad in terms of your post-investigation thinking and your pre-investigation thinking and scholarly publications, what would be, if any, the big difference between your post-investigation scholarly publications and your pre-investigation publications?
I'll answer the question maybe slightly not head on. I think that it's the case that the views that I had, the empirical views, if you will, the factual views that I had come to before I went to the Center for Advanced Holocaust Studies, and for which my time at the Center for Advanced Holocaust Studies provided a kind of general theoretical framework, one which I discovered, as I said, was very much in line with one major school of thought and understanding of the Holocaust. Those views, empirical and analytical, if you will, witness and expert, if you will, were not in any way significantly changed by the evidence, documentary, or in terms of pre-witness, witness testimony, as a result of my interaction, my employment by UNAKRT to assist the trials. So again, I think the major turning point in my thinking occurs before the court is established. It's not changed as a result of my employment, either full-time or as a part-time consultant. If that was employment, I guess that was employment. It's salary, not funding. I was an employee, not a grantee. Wasn't changed by my court experience, nor by the little bit of additional field research that I did in the latter part of 2011 after I left the court, but before I decided I was done for now with research on the Khmer Rouge.
So to summarize and to take a different angle on this, and that will be my last question on it, the things that you wrote in 7 Candidates for Prosecution and its sources, that is still, also after the investigation, your view of what happened in the DK period 75-79, more specifically as to the roles of the 2 accused. Is that correct?
President, witness, please wait. The lead co-lawyer, you may proceed.
Yes, Mr. President. Well, I would like to make an objection now. I could have made it regarding the previous question. I think that asking a person how his thoughts have developed, how his opinions have developed, how his analysis is different now, this means putting questions to an expert and not putting questions to a witness. My colleague was very mindful of the fact that we wouldn't step beyond that line, and it wasn't very easy, but I think here these questions are being put to someone as an expert, asking this person to define the developments of his thoughts, and that's why I object.
If I may reply, Mr. President, this is exactly a question where it's not about his opinion. It's about the development of his thoughts leading to academic articles and publications before a certain point and afterwards. So we have been asking this witness all along about his academic publications, so it would be perfectly within the realm of Mr. Hedder here being a witness to ask this specific question. I'm not asking for an opinion. I'm asking about the development within himself, so to speak, in respect of the DK period.
President, the objection is grounded by the lead co-lawyer for civil parties to the question by the International Council for Nuon Chea to Steve Hedder is proper thus sustained. The witness Steve Hedder appears before this chamber as a witness. For that reason, the questions shall be put to him as a witness, not as an expert, and for that reason, the defense counsel, you are instructed to rephrase your question, and the witness, you are directed not to respond to the last question.
I'm struggling how to reformulate my question. Maybe if I put it very simple. Mr. Hedder, are your views as laid down in your book, 7 Candidates for Prosecution, today still the same?
Mr. President.
President, the prosecution, you may proceed.
Mr. President, it's the use of the word views, I think, that causes problems, because views are expressions of opinion. There is a way my learned friend could ask the question, but I'm not going to tell him how.
Thank you for your help, my learned friend. The things that you have written in your book, 7 Candidates for Prosecution, and the sources that you have been using to write those things, are they still reflective of your knowledge as a scholar today?
Broadly speaking, yes. I mean, what's stated in 7 Candidates is like what's stated in reassessing, reflective of my interviews and other first-hand personal or documentary knowledge. But it's only a part of the picture. It's a matter of emphasis or research focus. So I would describe 7 Candidates as less complete than what's in reassessing, but not at all entirely antithetical. There might be some, if I redrafted, recirculated, and republished it now, there are probably some changes that could be considered qualifications that I might make, but it would be more one day, once all of this is over and everything is available, a matter of resituating some of that evidence, or some of that data, some of that material, rather than changing it.
I would love to have a longer conversation with you, Mr. Hedder, but I have to move on because of time constraints, and that is going to the methodology used in your academic publications and books, etc., that we have been asking so many questions to you about. And by way of introduction, in respect of the used methodology, let me just quickly, for time's sake, quote a few comments that you have made in respect of the methodology used by Ben Keenan in his book on Pol Pot. And just to give a very quick selection, I have written down that you are saying that Keenan sometimes uses false evidence, selectively documents, has come to baseless conclusions, is sometimes misleading, is sometimes wrong, is sometimes inconclusive, and is sometimes using stereotypes. Now, I'd be happy to present the ERN numbers for the prosecution, so the prosecution can confirm that I have, in fact, summarized it well. When it comes to false evidence, it is ERN 773753. The selective use of documents would be ERN 773744. The baseless conclusions would be ERN 773724 or 773747. The misleading in respect of the charm would be ERN 773726 and the ERN 773732. Where Keenan is wrong, fundamentally wrong, that would be ERN 773736. Where Keenan is inconclusive, that would be 773764. And where he is using stereotypes, that is on that same ERN number.
President Counsel Vita Coupe, could you please slow down when you read the ERN number as the interpreter cannot catch up with you? Please repeat those ERN numbers.
All of them?
There are two issues. First, please specify all the ERN numbers again. And secondly, whether the document that you refer to has been placed before this chamber. And before that, I'd like to give the floor first to the prosecution.
Mr. President, I hope it might save time because my objection is actually to relevance. How is it relevant for you to receive Mr. Hedder's opinion on Mr. Kiernan's methodology? It's wholly irrelevant. So my objection isn't just to E numbers. This line of questioning is wholly irrelevant. By all means, ask Mr. Hedder about his methodology, which I've already covered at length, and I hope there wouldn't be unnecessary repetition. But you're not going to be assisted by receiving Mr. Hedder's opinion on Mr. Kiernan's methodology. And it's for that reason that I object.
Mr. President, I was trying to save time.
President, the international lead co-lawyer for civil parties, you may take the floor.
Oui, Monsieur.
Yes, Mr. President, I perfectly support the prosecutor's objection. Second, is a comment on the way my colleague mentions the documents he wishes to use. We never get the document reference, first of all. We don't know, or we cannot check if this document has been placed on the case file or not. That's the first thing that should be provided, is the document index number. Now, regarding the ERNs, we all here provide the ERNs in all three languages, but the Nguyen Chia defense believes that it's beyond this. So I would like also the Nguyen Chia defense to abide by this obligation to make things easier for us. Thank you.
I understand there is no point in saving time. I will do it slowly, and I'm referring to an E131/1 13.3. It's Steve Hedder's article called Racism, Marxism, Labeling and Genocide in Ben Keenan's The Pol Pot Regime. We have extensively been discussing this article already earlier. I will give you the ERN numbers, English ones again, together with the French and Khmer ones. Kiernan sometimes uses false evidence. That is ERN 773753. French ERN 00802825. Khmer 00844599008444600. The selective use of documents, that is English ERN 773744, French ERN 0080281, Khmer 008445591 up until 92. The baseless conclusions, ERN 773724, French 008028111, Khmer 008445572 up until 3. Misleading, ERN 773726. That is French 008028112, Khmer 008445574. Kiernan is fundamentally wrong, would be ERN 773736, French 00802802816 up until 008028117. Khmer 008445583, 00 up until 84. Inconclusive would be ERN English 773764. In French, that would be 00822830, excuse me, up until 31. And Khmer 00844. 609 up until 610. And finally, Mr. President, the stereotypes accusation, so you will, is on that same page. I'm using, and that's why I think it's relevant, as an introduction to the methodology of used by this witness to
President, the international lead co-lawyer, you may proceed.
I simply would like to draw your attention to the fact, once again, that the references are given so quickly that they were not provided by the French interpreter. I just simply want you to notice this. So I would like at least for him to respect our right to know what he's talking about.
President, the observation is appropriate. Defense Counsel, once again, please slow down when you reach the ELN numbers so that it can be simultaneously interpreted into the other two languages. And this is not the first time that the Chamber has reminded you and other parties. And for that reason, please try to use the time effectively. And if you keep pushing through quickly, then it's going to backfire as it's a waste of time, not an efficient use of time.
I had hoped my learned friend from the civil parties had read this article and would find these conclusions or these observations of Mr. Hedder, that she would recognize them. So I'll skip all these ERN numbers because I don't have the time for it. I'll move on straight, Mr. Hedder, to your methodology. As I've understand your testimony, you, when writing your academic scholarly publications, have used interviews of former DK cadres. You have read documents like Revolutionary Flag. You have used U.S. intelligence, newspaper articles, etc. Other publications of other historians, academics, etc. And you have used extensively confessions of cadres who were interrogated in S21. Let me start, if you allow me, my question in respect of the interviews that were given to you by former DK leaders or cadres. More specifically, to limit myself to one interview, the interview that you had with Ieng Sary. Now, the prosecution has asked many questions in respect of that particular interview, and you have always confirmed that this was something that Ieng Sary had in fact told you. My question to you would be, if you remember what you did in preparation of this interview to make sure that the answers given by your source were not somehow directed by a hidden or a double agenda. For instance, you spoke to Ieng Sary in a politically turbulent time. It was a period that he had been won over by the then government in Cambodia. What did you do in that interview with him to make sure that he did not give his answers driven by a double agenda?
Is the question whether I had a double agenda or he had a double agenda?
He.
I mean, if he had a double agenda, of course, that was, in a sense, his right to have whatever agenda he might have had. I think his... I mean, if I were to guess, to try and figure out what was in his head, part of the context of this, and this actually relates to your previous question, by sheer chance, circumstance, Ben Kiernan, among others, had widely asserted that Ieng Sary was brother number 2. And I was fairly confident on the basis of my previous research that that was incorrect, that in fact the person widely known within party circles as brother number 2 was your client. So in the context of Ieng Sary's purported leadership of a breakaway of Khmer Rouge elements or PDK elements, It was widely reported on the basis of the assertions by Ben Kiernan and others that brother number 2 had emerged. And I had said to a number of people that I didn't think that Ieng Sary was brother number 2. I thought that Nguyen Chia was brother number 2. And I think Ieng Sary, to a certain extent, wanted to use this interview as an opportunity to attempt to confirm that I was right in my conclusion that it wasn't him, but Nguyen Chia who was brother number 2. And certainly what he said, seems to confirm that position. So yes, I think he had an interest in contributing to the refutation of to my mind, even before the interview and certainly ever since, the notion now, which I think everybody has dropped, at least in the scholarly community, don't know about in here, this notion that Ieng Sary was brother number 2. So if that's what you're after, I think that's probably correct, yes.
Maybe also in more general terms, Philip Short has written in his book that that Ieng Sary is devious and manipulative. When you interviewed Ieng Sary, was that something you could hear in his answers as well, or were you, before you went into that interview, cautious about his alleged manipulative personality?
I think the broader answer is he, like almost virtually every last one of the other former CPK cadre, that is, persons in a position of at least some authority, to whom I have spoken over now too many decades, seem to be at pains to try to convince me that they themselves were not responsible for all the terrible things that some, but not all, but most admitted had happened. So it has rarely, if ever, very, very rarely, if ever, been the case that somebody admitted direct responsibility, or what in their mind was direct responsibility for what happened. And I think, this is the same experience that, if I recall correctly, has been recounted by Chang Yuk and others from DC Can. So in that sense, again, like almost everybody else, he seemed to be at pains to try and convince me, persuade me, that he was not responsible for those matters, or at least not directly responsible. Not directly responsible in the layman's sense that a scholar and not necessarily an international criminal lawyer would understand it. That's a separate issue. This wasn't a courtroom. He wasn't represented. I didn't have counsel present either. So this was a conversation on a different level.
More concretely, would you be able to say, after the conversation that you had with Ieng Sary in 1996, which parts are truthful and which parts are not truthful, or rather which parts are which parts of the interview are confirmed by other sources that you have approached and talked to?
Mr. President, I let the last question run, but certainly not this one. It's an impossible task for Mr. Hedder, even with a witness hat on. It's an impossible task for him to determine during which parts of the interview Ieng Sary was telling the truth and which parts he may not have been, and for what reason. Whether Ieng Sary was telling the truth in this interview is entirely a matter for the trial chamber and it's not something which Mr. Hedder can properly be asked, nor should be asked to give an answer upon, and I object.
My learned friend is, I think, making a mistake in the interpretation of the word truth. Obviously, there is a trial truth, a legal truth, so to speak. But any witness in any normal conversation will be able to make an assessment based on his human nature and the human nature of the other person that he's interacting with, whether this person is telling the truth, yes or no. So that's not a question as to the legal truth. It's a question as to the truth in the sense how it came out in the demeanor of Ing Sari at the time. But not only this, I was also asking the witness if the things that Ing Sari had said in that interview were somehow confirmed by other sources that the witness has been speaking to or had been reading. So I think it's a perfectly legitimate question to a specific witness in respect of an interview that he had.
The President, the objection and ground for objection by the co-prosecutor to the question by the counsel is appropriate, and therefore this objection is sustained, and witness is directed not to respond to the last question posed by the defense counsel.
I'll move on, Mr. President. Mr. Hedder, you have written many articles and many books in respect of the Democratic Cambodia period, 75-79, and the CPK policy and the views on communism. I've also noticed that you have never been able to speak to many senior leaders of the DK period. You haven't spoken to Pol Pot, you haven't spoken to Nguyen Chia, you haven't spoken to Tam Mok, you haven't spoken to Son Sen, Vorn Vet, obviously you couldn't have. Same goes for Sao Pim and Rosnim. Would you be able to tell us something in terms of methodology, whether that was a problem, or you saw that as a problem in writing your academic publications and books?
I'll be my pedantic self and say it's not true that I haven't spoken to Nguyen Chia. I have. It's not true that I haven't spoken to Son Sen. I have. It's not true that I haven't spoken to Tam Mok. I have. But it is true that I didn't speak to them substantively. I met your client at his home in Wat Go in Battambang at one point. He didn't tell me much, so there's not much to say about that encounter. And of course, it's obvious that the more sources, the better. And every gap in sources brings with it certain weaknesses. Makes the case that you're making, be it an academic or legal case for that matter, less strong than it might otherwise be. And in the real world, scholars and legal practitioners alike face this problem. I think we all face this problem. And if I might be allowed, the reality is that from a comparative perspective, comparative political science perspective, comparative historian's perspective, the data be it evidence or not, be it deemed probative or not, that we have with regard to the Khmer Rouge regime is less quantitatively and qualitatively less good than that which we have for the former Soviet Union, for Nazi Germany, even arguably for China and Vietnam. So yes, these gaps, these absences are a significant problem with regard to drawing conclusions, historical, political, scientific, or otherwise, with regard to what really happened and how it happened and why it happened under that particular regime.
In your work, Mr. Hedder, your publications, sometimes you're only referring to a publication of one writer, sometimes Poncho, for instance, sometimes Donald Kirk, sometimes somebody else. Now, would you be able to tell us how you went about in the selection of specific books or articles, in general terms, when it comes to your publications?
Well, in part, this answer is a subset of my answer to the previous question. As a Khmer Rougeologist, going to the U.S. Holocaust Memorial Museum, going to the Center for Advanced Holocaust Studies, and seeing what they had in terms of secondary materials, and now we're talking about secondary materials, in their center library, certainly would make one want to cry, because in terms of the richness of the secondary literature, the situation is, the contrast is, if anything, even more stark. What happened in Nazi Germany, what happened in the Soviet Union, what happened in Mao's China, what happened, at least during the revolutionary struggle, if you'll accept that terminology, in Vietnam in the 60s, has been written about much more than what happened in Cambodia under the Khmer Rouge. So there's a lot more to choose from in those other instances than there is in this instance. And I guess in terms of choosing sources for working on the Khmer Rouge, my bias would be in favor of those who, in some sense, to my mind, were on the ground. The more time they spent in Cambodia, the more people they talked to while they were in Cambodia, the greater the effort they made to get out of Phnom Penh, and the like, the more generally likely I was, I suppose, to feel that their secondary writings, these secondary sources, were worth consulting and citing.
Let me follow up on that, Mr. Hedder, giving you one example, the book of François Poncho. I'm sure you have read the extensive criticisms that Michael Vickery has on the use of interviews by Poncho in the period after 17 April 75. Can you tell us if you have somehow incorporated these criticisms of Vickery in your writings?
This is a realm of some irony, because it's not so much the, well, let me back up. I think in general terms, my experience has been that there's no fundamental problem in relying on what's sometimes deprecated as refugee testimony in attempting to ascertain the truth, to use the phrase that's the legal favorite in the court. And indeed, it's certainly the case that if you look back on the sometimes somewhat sad history of understandings of democratic Kampuchea when democratic Kampuchea was in power, and the stated public or published positions of the then tiny little group of scholars, academics who looked at Cambodia in that period. The crucial moment, it seems to me, in their understanding of the regime, and the moment at which most, if not all, came to what in retrospect seems to me to be the right conclusion about what was going on, is the moment at which they began talking to large numbers of people who had direct experience and upon whose accounts of those direct experience they relied. So in general terms, I think that's not a huge methodological problem. And then to return to the realm of irony, much of Michael Vickery's own work relies on testimony or interviews, if you prefer, that could be categorized as refugee interviews, and indeed in many instances interviews that were in fact conducted by me, the results of which were made available to Michael, and which Michael then interpreted in some instances, at least many instances at the moment, back in those days, in a manner that was not the same as my interpretation of the data. That said, there's a kind of irony on top of the irony, which is, in some ways, the conclusions that are stated in among other places, reassessing, resonate, echo what Michael has said about the Khmer Rouge regime. The difference, again, is not... There's a similarity in the extent of the emphasis on bottom-up initiative, bottom-up deviation, bottom-up abuse. The major difference is my attempt to say this is characteristic of communist and other such regimes, and Michael's attempt, which resonates with Kiernan, to suggest this has nothing to do with communism, this has nothing to do with Marxism, Leninism. It's some kind of non-communist, anti-communist phenomena. So again, in some senses, in the Hederian version, in the Vickery-esque version, much of the basic description is similar. The analytical conclusions, the expert opinion, if you will, derived from that data. The descriptive part, which is closer to what I understand a witness does, is in fact rather similar. And no coincidence, since, as I said, in many instances he's relying on stuff that came from me.
I'm following your answer well, I think, but just to be clear and give you a very concrete example in terms of percentages. In your reassessing article, you describe CPK documents, speeches, revolutionary flags, etc., in which the official policy is presented as, in the sense that 95% of the people in the decay period were good, and 5%, the remaining 5%, were, according to CPK official policy, no good and were enemies, or whatever you want to call them. Now, assuming for a moment, just for clarity's sake, that this 95% and 5% were accurate, what were your endeavors? How did you make sure that you were not only speaking to the people in these 5% or 10% or 15%, and not also to the remaining 95% of the people who were not seen as enemies? In other words, how did you make sure that when you spoke to people, you were in fact speaking to a selective section of the DK period people?
The President, Mr. Witness, please hold on. Mr. Prosecutor, you may proceed.
I'll try and count the objections on one hand. Firstly, making reference to supposed concrete examples without taking us to a page of reassessing. No document reference, no page reference, no footnote reference, no ERNs. Secondly, referring to statistics, which takes us inevitably into the realm of expert evidence. Thirdly, asking the witness to make assumptions about 75% and 5% being accurate. Fourthly, then asking the witness how the witness made sure that the person they spoke to was in this group or not in that group, or representative of this group or representative of that group. It's an absolutely jumbled question, which in my respectful submission is going to expert opinion, and one which cannot be unjumbled and cannot be made admissible. So I object to the question in its entirety on all those grounds.
If I may reply, Mr. President, I've been trying to make things more clear by using percentages that the author has himself been using in a reassessing article. I've not been saying that these percentages were somehow correct. My point was very simple. What did the witness do when he was writing his articles? That he was in fact speaking to a proper cross-section of the population in the DK period between 75 and 79. If he was only speaking to refugees at the Thai border refugee camp, obviously this would give a completely different picture as to the living circumstances than if he would be speaking to peasants who hadn't been fleeing the DK period. So, let aside 95 or 5, I think Mr. Hedder is perfectly capable of understanding my question. It goes directly to the selective use or not of witness statements. So that is what it's all about. And giving the background of Mr. Hedder, he perfectly understands what my question is.
the President. I hand over the floor to Judge Jean-Marc Lavange to pronounce the ruling on the objection by the co-prosecutor to the question by the defense counsel for the witness. Judge Lavange, you may proceed, please.
Thank you, Mr. President. At the outset, let me say that the Chamber would like to point out to the defence that throughout the questioning of the witness by the prosecution or by the civil party lawyers, the defence requested that the witness be treated as a witness. Now, it seems that today the questions that are being put about the methodology used by Mr. Steve Hedder concern the methodology not of a witness, but of an expert. So, asking how he selected witnesses and how he conducted his work are obviously things that concern university work, the work of an expert, and they are not relevant in examination of a witness, Steve Hedder. The objection is therefore sustained, and we would ask you to move on to another subject. Thank you.
I'm not quite sure if I understand this ruling. The prosecution has been asking many questions, 2 full days of all, in respect of all the articles that this witness has written, asking about footnotes, about sources, etc. And now I'm asking about methodology. I'm not asking about an opinion of these articles, and then I'm cut off. And may I remind the Chamber that I think the defense should be given a little more leeway than we have been given so far. We're questioning Mr. Hedder, who I might call Mr. Khmer Rouge Tribunal. If it wasn't for him, we wouldn't be here. So I think I should get some more leeway in my questioning. So, but nevertheless, I move on, Mr. President. Sadly, I have some questions, Mr. Hedder, about the use in your articles of confessions. Would you be able to describe how you used those confessions in your articles?
Mr. President, I object. I hope you remember on the first day of my questioning that I made it absolutely plain that no question I asked Mr. Hedder would be about confession material. I said on day one that I was certain of it. In other words, that I was certain that no question I asked would be based on confession material. And I challenged the defence to intervene if I did. In 2.5 days, I did not ask questions about confession material, and in 2.5 days, the defence never suggested that I did so. Confession material has been rightly excluded from this case, generally speaking, unless it's, for example, an annotation on a confession or a letter accompanying a confession. This chamber is not going to be assisted by hearing answers from Mr. Hedder about confession material. That material has been excluded, and given Judge Laverne's ruling, this is not an appropriate subject for Mr. Hedder to comment upon. I have not touched upon confession material, and neither should the defence, unless it's for permissible reasons.
Mr. President, there's a big difference between the question whether we can legally use, for probative value reasons, confessions in terms of evidence. I'm now asking the author of many articles and many books about his use of confessions and the way he has used confessions to come to whatever he has been writing in these books. So there's a big difference, a huge difference in the question whether you, as a court of law, can use it for probative value reasons or for reaching a judgment on the basis of that particular evidence, or to the use by this author of many books of confessions. Apparently, this witness, when writing his book, has used many, many, many confessions. And he came to certain conclusions. Now, I'm not asking about his conclusions on the basis of these confessions. I'm asking simply about the way he has been using these confessions. Now, sadly, there is an article, very interesting article, from the hand of Mr. Hedder himself, which is not part of the case file. So, for very formalistic reasons, I will not be allowed to use it. It's an article called the Khmer Rouge Opposition to Pol Pot, pro-Vietnamese or pro-Chinese. And it's a very interesting article from Mr. Hedder about the way he is using confessions and about the dangers which exist when interpreting the literal text and meaning of these confessions. Now, I think Mr. Hedder is perfectly capable and perfectly allowed to give us his views on the methodology when it comes to confessions in respect of the publications that he has written.
Take him to a passage. Take him to what he's written. Take him to his footnotes. Extract the footnotes and you're left with the admissible material in this case. You're not going to be helped by, look at this passage, there were 16 confessions, irrelevant. What's the point of you hearing from Mr. Hedder how 16 inadmissible confessions related to a footnote? I've extracted all the confessions for my examination, and the defence should do the same. You're not going to be helped by hearing how inadmissible confessions were part of the writing of a book.
I'm sure you can reply as well. Please, Mr. President, there's a difference in standard when treating the defense when it comes to this particular witness than the prosecution. We have all heard today this witness has written this book, 7 Candidates for Prosecution. He worked for the prosecution. He worked for the judges, the investigating judges. And now I'm trying simply to ask questions about the methodology used. Now, if I'm provided the exact same standard as the prosecution, that would be completely unfair. So it is appropriate and within the realm of the capacity of this witness to ask him about his particular use of confessions. How did he deal with language? How did he deal with literal meanings? How did he deal with, when did he decide a confession was valid and could be used for his research and his publications? That is a perfectly valid question. It's not a question about his opinion, just a question about how he uses confessions, how he uses interviews, how he uses intelligence, how he uses newspapers. That is within the realm of this particular witness.
President. I hand over the floor to Judge Jean-Marc Lavange to pronounce the ruling of the Chamber regarding the objection by the prosecutor to the question put by the counsel. Judge Lavange, you may proceed, please.
Merci, Monsieur le Président.
Thank you, Mr. President. The Chamber considers that through the questions being put to witness Steve Hedger, the defense of Nunchia is attempting to assess the quality of the work of an expert, and the same point applies to all parties. The same requirement that was demanded by the Nunchia defense, namely that Mr. Steve Hedger should be treated as a witness, not as an expert, that same demand applies to the defense of Nunchia. And so we are not going to authorize this line of questioning, and we ask you to move on to another subject.
The President. Thank you, Counsel, and thank you, Mr. Witness. Now it is an appropriate point to adjourn for lunch break. The Chamber shall adjourn now and resume at 1:30 this afternoon. Court officer is instructed to assist the witness during the break, and please have him return to this courtroom by 1:30 this afternoon. And security guards are instructed to bring Mr. Kyew Sampon to the holding cell downstairs and have him return in this courtroom this afternoon before 1:30. The court is now adjourned.